why do you need a will if you have minor kids? Hi, my name is Claire Lincoln-Yanowitz, and we've been helping families protect what matters most, including their children, for the last 30 years. Okay, let's get started. So having a will is so important if you're a parent for two major reasons. First, you want to be able to nominate who is going to be in charge of raising your kid if for some reason you're not here to do it. So with a will, you can nominate who's going to be the guardian of your child if you're not here. And oftentimes when we ask clients, who do you want to name as a guardian? They'll come up with a couple. We want to name Bill and Sally. And then I ask my clients, well, what happens if at the time of your death, Bill and Sally are divorced? Do you still want to name both of them? And in which case, most of the time, my clients will say, nope, Bill's my brother, Sally's my sister-in-law, I want to name Bill. So then we'll just put down Bill. And then if at the time of the death, he's with Sally, Sally could be nominated as well at that time. So that's something to know. When parents pass away, they have to have a court hearing to get the guardianship in place. So they look at the recommendations under the will of who would be the guardians, but they still do a background check and there's a court hearing to get the guardianship in place. It's not automatic. Second, when you have minor children, you want to make sure that they inherit in a trust at your death. They can't inherit outright. So that's another really important reason to have a will. So you need to have a will at your death that sets up a trust for your kids' benefit, or you need to have a revocable trust that morphs into a trust for your kids' benefit at your death. Why is that so important? Because if you just give everything to your minor child outright, it's going to trigger a court-supervised conservatorship, where the court is going to appoint someone to be in charge of managing your children's money for them. And that person is called a conservator. The conservator is going to have to keep records with the court down to the penny of how they're spending the assets. They're going to have regular hearings every couple of years, most likely. And at age 18, the conservatorship will completely evaporate. Your child will get dished all the money to them outright. They'll be able to spend it however they want. And so I know a lot of parents, would say that, my 18-year-old may legally be an adult, but they don't have the financial seasoning or sense to handle an inheritance that, we'd prefer to have someone else be in charge of this until my child is a little bit older. And that is another good reason to have your children inherit in trust, because if they inherit in trust, you can extend the period in which they inherit further. So oftentimes a lot of parents will continue to have this trust last until their child is in their 20s, maybe 30s, so that some other adult is in charge, making a plan with investing, making sure that your kid's spending the money wisely. And then when your child is less of a young adult, more of a middle-aged adult, they get the full horse reins and they can spend and invest the money however they see fit. Thank you so much for listening today. If you have any questions, our team would be happy to help answer them. Otherwise, feel free to subscribe to our YouTube video so that you can learn more about wills and trusts and be notified as we post more videos to our channel. Thank you.